Sorry for the delay. Probably lost everybody.
Got it?
Yeah. I'll repeat when Val Brady gets back. It's in numbered paragraph 43. Should any, and I'll just read it. It's very simple and straightforward, but I think it's very significant. I want to make sure the people on the City Council understand that it's in there. Should any portion of the settlement agreement be declared invalid by any court, this settlement agreement shall be declared null and void for all purposes. I believe that provision is very significant for the City of Lincoln Park because let's say that the broad prohibition against new enactments were to be challenged. Let's say you found something you really wanted to enact. Went to the other side, the other party said, we really think we need to enact this for the regulation of adult businesses in the town. We don't think it's a violation of that settlement agreement, but we still want to enact it and we want to clear it. They say, oh, we think it's a violation. Okay, this one's important enough. We're going to challenge that term and have that one determined invalid. If you do, and you win, the whole thing goes. Lock, stock, and barrel, because then it is null and void for all purposes.
So that would be leverage on our part.
That's a good thing.
That's a good thing for the city.
A big one.
It's a very significant provision. I don't think that particular interplay was anticipated or somehow put in there to be an advantage to you. But I think what you have is you have one provision in there about no new ordinances that is overwritten to protect plaintiffs. And you have this provision, which is if any part of it goes, it all goes, which you combine the two, it gives the City of Lincoln Park a provision that I think you could challenge and have a reasonable chance of succeeding at. And if you do have to challenge, and you do, and you win, the whole thing goes out. Absent a crisis, I don't see a need to challenge it now. Which goes back to my earlier and broader opinion that I don't think it helps to undo it right now. Because I don't think you're going to get any meaningful, better result in the particular case that you were faced with. And in the long term, if that anti-regulatory provision becomes burdensome or onerous and you come up with various ordinances you think need to be adopted and you can't get them adopted or these people don't want to agree to it, then it's time to pick the fight. Then you have a specific issue, a specific reason, and I think the other side is going to be motivated to talk to you because
43.
If you win, it all goes. So, that too is a very candid, blunt assessment of what you have here, and in some respects it tips a hand, if you will, to the other side, the plaintiffs, if you had to litigate or fight with them. But it's not a secret. I mean, the careful reading of this whole settlement agreement shows that you have the provision in there that seems a bit overwritten for a municipality, against you, the municipality, and you have the provision that says if any part of it's found invalid, the whole thing goes out. So I think you have a card to play, if you will, a legal card to play that's a very powerful one, if and when you need to play it. And that's why I think that the future enactment of ordinances, if you have one that you specifically think you need to enact and you really think it's important to the City of Lincoln Park and you think this settlement agreement may get in the way, I think you have some leverage to sit down to the other side and say, here's what we want to do and why. Here's why we think you guys should not be in the way of it. We're trying to assert this settlement agreement, and if you want to fight over it, we can fight over it, but we don't need to. I think you have a way to do that, rather than just arguing blindly or proceeding blindly. I think you've got a solid legal basis here if you really need to go ahead and open that window of opportunity for additional regulation. And I think that's an important one. I thought before I came down here about whether we should do that in open session, but I decided there's just no other way to do it for you.
Right.
To explain it.
And what would be the third item? The stage setting and the separation would be the third problematic item?
In terms of enacting an ordinance, if you had your way or if I have my way, I'd like to see that one back in there. but I don't see that particular provision as the window of opportunity by which you can open everything up. The only window of opportunity by which you can open everything up is that overwritten section that says you can't adopt any new ordinances. So within that window of opportunity, I think you have to select any additional ordinances carefully that you really think you need, are really going to be helpful, and then go to the step of trying to get them adopted, and then see if you have to fight this battle or not with the other party.
You know, my recommendation was to put some stricter enforcement on our prostitution ordinance, and I don't even know how that they could even possibly contest that one, because it doesn't, prostitution's illegal no matter what. So I don't even know how they could have come back and argued that one or even protested that one at all.
You're right. I don't think the ordinance is aimed at limiting
An illegal
prostitution fall into the ambit of what's in this consent judgment about regulation of adult businesses. Prostitution doesn't qualify as one of the adult businesses in here, so that one doesn't come into play.
And that would be one of the secondary negative effects that we can anticipate probably seeing. And we've seen it with our existing.
They go with the adult businesses. How much is different from each business to each community, but some of the negative secondary effects include the increased crime rate in the area, the perception of a deteriorating property value, even though there may not be, a perception that a community is less safe immediately surrounding one of the adult businesses. Those are common perceptions, whether they're real or not, they're common. The increased crime rate around them is a common negative secondary effect, but it doesn't have to exist around every one of them. It's a common.
Thank you. Thank you very much.
Probably should do more questions, though, right?
Yeah, absolutely.
Mr. Mayor, can I ask a question at this point for clarification on a couple of things? Looking ahead and moving forward, the ordinances that have been proposed, I don't see directly relating to the Hustler Club operation regarding hotel, motel operation, the public exposures and that. It was my understanding that those would not be the type of ordinance that would be affected by this consent.
You're right.
Okay.
And that's why
It's kind of what I think she just asked and you asked again in a little more detailed form, but I don't see the consent judgment or settlement agreement precluding the adoption of either one of those type of ordinances. That you folks have been talking, the motel rooms and then this public exposure one that I haven't looked at that closely, but I don't see that one as fitting into the context of the settlement agreement or consent judgment.
But it would still regulate the negative secondary effects.
Sure.
As a follow-up to that, one of the concerns, and I ask maybe just publicly given a little bit of a guidance here, when you have a situation where there doesn't appear to be statistical support for what is intuitively a predetermined condition, frankly, some of the hotels and that are some distance away from this site. Intuitively, people feel, but police department statistics may not support activities that are known or felt in that. What is our best methodology now to approach this problem to give the necessary statistical research basis for the legal perspective to proceed to support some of these ordinances without interfering or without singling out or selectively enforcing to deprive anyone of their particular rights?
One very basic step is to ask the class of businesses to be regulated to tell you what they're doing. That is easy, it's direct, it involves them, it gives you data as to whether or not there is the hourly room rentals, what the rates are, if they do it daily, weekly, monthly, and where. Find out if it's happening, first of all.
I've done that. I've done
Okay.
that.
If you have that kind of a database, that tells you that there is a practice going on. Then you would want to look to see if there is any correlation between that activity and any of your police work activity. Just, real common sense stuff. If you have a place, a facility that's offering rooms for rent by the hour. And that particular facility over the last year, while they've been doing this, has also been the site of other crimes, whether they're assaults or prostitution crimes or soliciting or drug use or anything else. Then you're going to have some kind of a correlation between crime rate and that hourly room rental. That's just right there in front of you if you ask for it and look for it a little bit. If you don't have any statistical backup, then you'll probably have to dig a little deeper to find out what's going on with the hourly rentals, and I don't know what it would be.
The question I just have a concern is that prima facie there's some evidence that some practices may be in place by the private establishment, but unless there is the crime statistic correlation, we really can't suggest that this activity is leading to exacerbating crime problems in the area. So that was some areas I just wanted to have you comment on.
Other than your own experience here in Lincoln Park, the only other thing to do is to check with other communities to see if there is any statistical correlation between criminal activity and those hourly rental rates or hourly rentals of motel rooms. And I don't know the answer. You just have to do the research. It's always better on one like that, a regulatory issue like that, to look and see what you have in your own community. You know, that's really the best indicator of whether or not you need to regulate.
Mr. Mayor, one other question now. It has been given to me as an opinion that the Liquor Control Commission rules regarding dancer distance and participant distance inside in regulated establishments is certainly in place with its consent. That's been my understanding. Could you comment on what the LLC rules are regarding that?
I don't know what the current rule is for the LCC in terms of distance, if it's performers or waitresses. These folks are saying that they're not going to have any waitresses. They're only going to have performers, and I can't quote the distance. I'd have to get it for you.
Thank you.
I don't have it. I can tell you that many communities, if not most communities in Michigan, don't try to regulate that issue themselves. They let the LCC do it. And they figure the LCC has got a better regulatory hammer to wield over the license holder because they can pull the license for violations. A municipality can write tickets for the violation of its own ordinance, but the municipality can't pull the liquor license or the topless entertainment permit. The LCC can do all of those things. So many communities don't try to enforce their own local rules on the liquor licensed establishments. They let the LCC do it. And that's why. But I can look for you and find that specific reg, whatever it is, and send it down to you folks. I just don't have it in hand tonight.
Thank you.
Ms. Brady, do you have more?
Oh, thank you, Mayor.
Councilman Myers.
Well, thank you, Your Honor. Mr. Williams, I have a few questions, and some of them are for citizens, and some of them are for me. The first one is, a citizen asked this, is both page 10 and 21 dead end in the middle of a sentence. Is there any legal issue with that, or is that going to cause us any problems?
And are we?
We're talking about the settlement agreement.
I'd have to find it and look.
Page 10 and then page 21.
I thought you were saying my memorandum had
No.
a typing error in it. I don't see a problem with the error on page 10, and I thought I had that figured out at one point, but I don't have a note.
It kind of just leaves you hanging there.
It does,
Yeah.
it does, and when I was going over this, I thought I found the concluding phrase to it, but I don't remember where, and I didn't mark my copy. I did not think that was a problem. I noticed that one too. What's the next one, though?
Page 21.
That one was not a problem. I just read that as ending in concept at section 1260.01. It's sloppy
Right.
wordsmanship, but I don't see it as a problem. And whoever posed those questions is a very careful reader.
Well, I think a lot of us noticed it, but the person that posed the question is a very careful reader. He's been up here a few times. We talked about the Grand Rapids challenge
Yes.
a little bit. And I'm under the belief that there's currently an injunction against the enforcement of the nudity ban by the Liquor Control Commission from the Sixth Circuit Court of Appeals on Bogarts versus Grand Rapids. And that they're waiting for the state to provide an argument about why it's needed, why a nudity ban would be required.
In general, there are a couple of terms in there that I can't say for sure, but in general, there's an adverse decision against the state on the anti-nudity provision. I don't think that case is over. It's not done yet. There is.
Well, this is from.
There's some worry across the entire state for all municipalities that the anti-nudity provisions enforced by the LCC may fall completely. And that's beyond the scope of what Lincoln Park or I can fix.
But did you consider the possibility that Papolis may use this injunction to establish nude entertainment?
Yes. I don't think they're going to prevail ultimately on that issue with regard to state regulation and the liquor licenses. There's one bad ruling against the state of Michigan on that subject. When it happened, I don't know how to say it, I guess, except bluntly again, it didn't make sense to me because across the nation there's been great deference by the courts to state regulation of establishments that serve alcohol and great leeway in regulating the conduct of people on the premises and the way the business is run, and regulations prohibiting nudity or limiting nudity in places that serve alcohol have been upheld all across the country. Michigan's pattern of regulation through the LCC is consistent with, I can't tell you how many states where it's been upheld. Michigan shouldn't have lost, we shouldn't have lost that case. I don't expect that position to prevail in the long run. I expect the LCC to retain its regulatory power over nudity in the liquor licensed establishments. But there is that one adverse ruling.
Right.
And I'm not questioning the authority of what you just read to me. I just don't want to make more of it than what it really is.
Well, I'm just concerned about it because it
I
does
am too.
open the door for them to just outright challenge it and start right away as a nude liquor serving establishment.
If that battle is fought against the LCC in the state of Michigan and the adult businesses win that battle, it's going to be a significant loss to municipalities across the state who are expecting the LCC to be able to regulate that very subject.
Right. And then
If that one happens, it's going to be one more battle in a large regulatory war.
What kind of makes me think about that is in the agreement they specifically exempt our anti-nudity ordinance for their adult entertainment performers. And that language is very specific for that.
It is.
And so I was concerned that may be part of their long-term plan.
It may be. I don't think it is a significant long-term risk that the state of Michigan is going to lose that regulatory power. But it is some risk, and you've correctly identified it.
I appreciate that very much. We have this is a little bit different kind of question. We have Faith Christian Church, which is across the street from the Papolis site, across Outer Drive. And it's in the city of Melvindale, not Lincoln Park. But there's a letter from McKenna and Associates dated June 23, 2006 that states that the church is within the 450-foot rule of our ordinance. However, at the time that the adult use zoning approval, I was told that this did not count as a church because They had a site plan approval, and their construction was nowhere near complete. And so my question is, should we have considered this as a church because it's in another city first and within the 450-foot rule? I mean, it's all these rules and regulations about the footage, and it's confusing to us.
I didn't research that one again recently to be able to answer it as well as I would have liked. There's been a split historically amongst municipal lawyers about how to measure those distances with regard to uses outside the boundaries of the community in which you're applying your zoning ordinance. And the older approach was not to count anything outside your boundaries. And I don't know if the Melvindale Church should be counted in your situation or not. I'd have to go back and compare dates.
Well, I'm not asking you to do that. I mean, it's...
I think the reality of what you have there is you have a site with a church where the folks that are participating in that church are going to be disappointed and bothered to have a business like that near them.
Right.
And they're not going to like it. I don't know that that means the adult business can't exist or can't be on that site. It just means you're going to have some neighbors who are going to be bothered by the presence of that business.
Let's see what else I have here. Well, a lot of it you talked with Councilwoman Brady about. It's about the mistakes made, the things that were done right by our city attorney and our city manager, about whether they should have done it, could have done it, and all of that. But my question is, what steps, or not what steps, but what would a city council do to seek a remedy in such a circumstance when we felt that we didn't agree with the actions of an official that signed an agreement?
Well, there are a couple different courses of action available. One is to go back to the federal district court, if the council voted to do so, and ask to get out of the settlement agreement because it really wasn't authorized. I don't recommend that for all the reasons I've explained earlier, and I won't rehash those. But that's one theoretical remedy. Try and undo it. Another remedy would be much more direct. If the city council as a whole decides that the city attorney or city manager acted inappropriately, then you can censure or reprimand him as the city council. I mean, those two folks work for you. And, that's an unpleasant activity to go through. But if the council as a whole determines that the city attorney did something that was contrary to instructions by the council, then you folks can tell them that. You did it wrong. And you can take whatever action then you think is warranted. From what I could tell, you folks have a divide within the council and between the city attorney and city manager and some parts of the council over who's doing what.
Right.
And it makes for a difficult working relationship and difficult working conditions. And that's not so much a legal issue as much as it is an administrative issue where you folks need to get that ironed out a little better. Right now, the communication level and the trust level is not ideal. It's not where it should be for good working relationships for all of you.
I agree 100%.
I don't have a good fix for that one.
All right.
Now, you guys got to work on that. But I'll digress just for a second to point out that when the working relationship isn't where it should be, or isn't ideal, you have problems like what you have right now. You have a lawsuit that some think was being settled appropriately, some think wasn't, and you have a disconnect. You have anxiety, frustration, added expense, and it's just not the way things are supposed to operate regularly. Sometimes you can look at them and say, whoops, we bungled this one up. We made a mistake. Collectively, we got to straighten it out. But there's a tone here of a bit of a divide amongst commission and your two chief officers And it just doesn't make for a good working relationship, and it tends to come out then. The divide shows itself when you have a tough issue like this one to deal with. And all I can say is I hope you guys can get that ironed out. It may take a frank discussion between the council as a whole and the manager and lawyer about how you want to see information brought to you on a lawsuit so you can resolve it. And I think I saw a resolution or two, while I was looking at other things, I think I saw a resolution or two after this situation in which you folks have directed manager and attorney to bring more to you with regard to settlements and lawsuits.
Well, we held that because I had submitted that resolution about the lawsuits, and we held it because we wanted to discuss it with our insurance carrier first to make sure that we didn't make a resolution that would cause them to cancel our insurance policy. And so until we talk to them, I don't want to go further with that resolution just now.
Okay.
And I just want to add that, had we paid attention to the agreement and done what the agreement asked us to do, which was to sit down and discuss and ask all our questions of the agreement before it was signed, we wouldn't be here tonight. We wouldn't have had any of this problems that we've had. And it all could have been saved had we just followed the stipulations that were clearly written in the agreement.
I don't have any disagreement with that. I'll add a little, I guess, just general advice. This isn't particular specific legal advice as much as from my experience over the last so many years doing the municipal work and going to communities where they've had a problem. And that is the closed sessions for the discussion of the strategy of litigation are helpful, but they can be overused. And what can happen is you do so much discussion in closed session that you don't get the opportunity to ask the tough questions in public session, and you don't get the opportunity for your chief officers, like your manager and attorney, to look you right in the face and say it's a good case to settle or it's not a good case and here's why. And you don't have the opportunity for the general public, your constituents, to sit here and listen to it and maybe offer their thoughts or criticism. So I would just encourage you to perhaps do more of it in open session.
Well, I think we have a fear of, revealing the lawsuits that come in. And, and Mr. Duchesne knows very well that Sterling Heights, they present all the lawsuits in the public meeting to the council that are served on the city. So they become part of the public record. And then they vote on it, but they're self-insured, so they do vote on all their settlement agreements. And I understand the difference, and I'm not going to bring that up. But, I think we need to be more open to the public about a lot of things, and especially what you suggested about discussing these settlement agreements where we can.
The lawsuits are always, they pose all kinds of difficult problems. There are things that people believe are embarrassing and they don't want to have to discuss it in public session that sometimes are the subject of lawsuits. All I can tell you from experience over it is it's much more embarrassing to have to take information that was first discussed in closed session and then bring it out into open session and then try and explain why you did it in closed session rather than just doing it in open session to begin with. So more and more, I think it's simply easier and more effective to do it in open session as much as possible, at least on a settlement discussion situation. When you get done with the settlement discussion, if you have to go into closed session, I recommend going into open session and taking some action to either authorize settlement, not authorize it, but publicly go ahead and make some kind of a decision so you've got it on the record, it complies with the Open Meetings Act, and there isn't any confusion then, hopefully,